Good evening, everyone.
Good evening.
Good evening, Ms. Archer. Good
I
evening.
love that.
Good
Everybody sounds
evening.
perky and ready to go. Why get silence now?
Yes, we are.
Ready to
Wonderful.
go.
Wonderful. I love that. You know, next week is midterm, so
Oh, Lord.
Listen, now you had to spoil it now.
Are you serious? Oh, Lord.
no, Mom, don't say that. I'm not spoiling. I'm just reminding you. It's
Thank
just
you so much for that wonderful reminder.
Is
Yeah,
it
just a quiet reminder.
Ms. Archer? The time is 6:30 at
At
BIF.
Let me double check and make sure it's not 6 o'clock. 6:30 is better.
Confirm reports too, please.
Okay, all right, I can do that right now. Okay. Right now. Next Monday. It's for 6:30. And what is the time for Freeport? Okay, I sent it. He should answer shortly. Okay, all right. So I gave you all some cases to look at. Not many. Silence again.
Did you send a separate
Yes.
email saying who they were assigned
We
to?
got it.
Yes, I did.
Oh, okay. No, I just asking. I didn't see one.
Oh,
with
no, I
the-
didn't. I didn't see the, I see the cases, but I didn't see the assigned persons to them.
Right.
That's not possible.
We didn't have
Yeah,
any time.
they sent all of the cases, but I don't see anybody assigned to anything.
Yes,
Hmm.
I sent that on February the 8th at 12:33. Escobar is Cassandra. Cornell and Maltby is Zenobia. Sylvan is Katora. Baxter is Stacy. And Park Tweedledale is Marissa.
Okay.
And I have Kendall, which was a leftover case.
I need to go
Yes,
back to my emails. I didn't see that. What's the name you said for Stacy?
Stacy was Baxter versus Gap. Remember, I told you all these are the cases for remedies. These are not long. Just read the summary that you'll find online.
Which one is Marissa?
Park,
I lost.
I didn't get it. I didn't get the email.
I didn't.
what? And so you don't know who was assigned for the cases either?
No, ma'am.
No, ma'am.
Oh, we don't know who's assigned to the
And I
case.
didn't
Yeah, I
see-
don't know who's
Yeah,
assigned.
when I didn't see anything, I thought that maybe you sent it directly to those who something was assigned to.
No.
That's why I didn't question it.
Yeah, I didn't see anybody assigned either.
Okay. So Peace Holding is Veronique.
What?
Yes. No, we'll do it next class.
Peace holding?
hmm
I printed everything out.
Okay, so Peace Holding is for you.
Okay.
Lawrence McKinney is for Sharice. Is she on? I don't see her on. Hold on, I
Ms.
think she.
Archer, when you finish, check your drafts and see if you send press send on that, please. I'm looking at the 8th. I don't see anything from you.
I sent it to Mr. Pratt to send to you all.
Oh, okay.
That's what I did. Because when I try to send the documents, it's too large. So I let him send it from their email.
Mm.
Yeah, he didn't send the one showing who they were assigned to.
Okay. Well, anyhow, I'll send it to you after class. So, hold on. Denise. Deandra, Marissa. I know I got an email from somebody. All right. Bentec is for, I think I have to change somebody's names. Because, oh yeah, Neely. Anais, Neely, that's what I say, or Neas. I remember I pronounced it wrong last time. She has
Anais.
Bentec, and Who? Anai? Okay. You have Bentak versus FCIB. Shantina, you have Finco versus Philip Mitchell.
Okay.
Michelle, you have the Court of Appeal. Philip Mitchell versus Finco. And Fountain, I gave you Evelyn. Chris.
Michelle has the Court of Appeal with Philip versus
Finco.
Finco.
Yeah. So Shantina has it in the first instance where Finco is exercising the power of sale. And then you have the Court of Appeal where the Mitchells do not agree with the decision.
Okay.
And what's the name, Miss Archer? You said just Finco?
Finco
Shantina.
versus Philip Mitchell.
Finco versus Philip Mitchell. Okay, thank you.
That's in the Supreme Court.
Okay.
Ms. Archer,
And
I
Ms.
didn't get
Archer,
it, right? Owen?
Which one is
Melissa?
Zenobia, please, Ms. Archer?
Zenovia is Cornell versus Maltby, which is tonight. You can find it on on the internet. It's very short.
Canal versus 19.
Yeah, Quennell versus Maltby.
And Marissa's?
And Marissa is Park Tweedale versus Dunbar.
Park?
Park.
Dunbar. Okay.
Confirming Joseph is Peace Holdings Limited and First Caribbean, right?
Let me see. Yeah.
Okay.
So we can have no delightful conversations tonight.
I mean, I did,
Can
I
we discuss
know I had
some of
Kendall.
the shorter ones?
I heard you, Krista. What did you say?
Sorry, I was asking if we can't discuss some of the shorter ones.
Yeah, we probably could.
Mhm.
Yeah, we could. I think so. All right, Krista, you go with yours.
Good evening, everybody. So I have the case of Kendall Marshall, Jacqueline Lockhart, and Gwendolyn King, trustees of the Victoria and Alexandra Union Society as the plaintiffs, versus Delcina Corley Saunders, the defendant, seen before the Honorable Madam Justice G. Diane Stewart. So Mr. Marshall ran point in this case because the other surviving trustees were a bit older in age and not of the best of health. He is or was the president and treasurer of the Union Society since 1987, succeeding the late Cyril Lockhart and Charles Rodriguez as presidents, both now deceased. The purpose of the Union Society was basically to financially assist the poor and sick with burials. The dispute was over a piece of land with a structure on it at the junction of, I believe it is Blue Hill Road and Dunmore Street. Yes, that's correct. So Mr. Marshall is stating that the last appointed trustees of the Union Society were himself and the others as named. Mr. Marshall provided a declaration of trustees that was dated in 2007 and prepared by Jacqueline Lockhart, who I believe was the secretary of the Union Society. This property had been conveyed to the society in 1919 with the original trustees.
Hello.
You got cut off.
Sorry, what was the last thing you heard?
Trustee.
Good night, sorry. Which case is this, please?
Kendall. Kendall versus Saunders.
Saunders, thank you.
You're welcome. Okay, so let me start back Okay, so I'll just go over in summary, just in case. So in 2016, the plaintiffs brought a case against the defendant seeking a declaration that they are the legal owners in fee simple of the property, which, as I mentioned, junction of Blue Hill Road and Dunmore Street. At the time, the defendant was living on the land. So the Union Society, according to the plaintiff, purchased the property in 1919 as recorded by a conveyance, which was between the original trustees of the society, Demerit Burnside Smith and John Cerruti. This conveyance created a trust for charitable purposes, the beneficiary of whom was the Union Society and its members. A building was constructed on the property in which the society held regular meetings. So moving on, in addition to the 1919 conveyance, in 1954, it was applied to the Supreme Court for an order to vest the property in the trustees on behalf of the Union Society. This order was granted in July of 1954 and a vesting deed was issued. The 1954 deed further recites that the members of the Union Society purchased the property sometime during the year 1904, and from which time it exercised undisturbed possession of the property. So according to the plaintiff, the defendant could not claim to own the property as she was doing, because she actually filed a counterclaim seeking possession of the property as the sole beneficiary. But like I said, the plaintiff said that she couldn't claim ownership as the personal representative of Gladstone Cerruti, who I'll mention later, because that person, Gladstone, never owned the property. And it was always in the undisputed ownership of the Union Society until 2006, when the defendant illegally ousted the plaintiffs. So it's useful to note that in subsequent years, from the time of the conveyance up until 2006, the society leased the building several times. The last tenant was to a private high school, the Renaissance Academy. So in December 2006, the defendant evicted the academy and took possession of the building. All of the society's records, deeds, and documents that were kept in the building were then lost. The plaintiff wrote the defendant demanding that she vacate. However, she did not. The defendant counterclaimed that the property was purchased in trust for the society by the 1919 conveyance, and that John A. Cerruti, one of the original trustees, died as the sole surviving trustee. She herself is the granddaughter of John's cousin. So the last surviving son of John, Gladstone, appointed her to manage his affairs through a power of attorney in 1995. However, the power of attorney did not specifically mention the property. She was also appointed as the executrix of his will and sole beneficiary of his estate. However, that also did not include the property. The will was probated and a deed of assent, which allowed her to manage his affairs, was granted in 2009. The defendant herself had been involved with the society since childhood, and she denied that the plaintiffs were the true trustees and affirmed that the Union Society itself ceased to exist sometime around 1969. Now, after the death of Gladstone, she said that, so his will was dated 1995. I don't remember seeing when it was probated. I believe it was some years later. And like I said, the deed of assent wasn't until 2009. But she stated that no other business was conducted in the building after his death. And that she did agree that she herself had been living there since 2006. So even though the defendant originally sought a declaration that she was the legal and beneficial owner of the estate in the beginning of the case, she later retracted and said she wasn't maintaining the property with the intention to own, but instead she was just caring for it as a historical building. I believe the case mentions that was declared by the Ministry of Works, according to her, and as per Gladstone's wishes.
Everybody know where the property is that we're discussing?
I don't.
I didn't.
You know now, Crystal, where it is?
No, I tried to find out. I would have actually driven past, but I'm off island.
Okay, so let's say you're on Blue Hill Road, you cross and you're heading north. You cross over Wolf Road,
Yes.
everybody, with me? And you're driving down now on the right-hand side. Remember those brown large house?
Mm.
On what side?
Yeah,
On
what's
the,
that?
would be on the eastern side, a wooden house. Have like a porch on the outside.
Yes, yes, yes. It used to be a church or something.
There you go, that's it.
Ah,
Okay.
Where, no, hold on now. Is this, where the Sunshine Twin
No.
Piano is in that area?
No.
No, past that.
Okay,
Go further north, go across past Fidelity Bank. You're heading
Mhm.
north
Yeah.
and it's on the
Okay.
right side.
Mhm.
okay, by where? Oh Lord. Okay, I know you mean.
Yeah,
Yeah, I know you mean now. Okay,
everybody
those two
thinks.
buildings, okay,
Yeah.
all right,
knows.
okay, okay.
Okay, go ahead, Krista.
all right, it's not a problem. So the defendant also admitted that Gladstone's father, John, and again, so if you remember in the beginning, she was stating that John was the last surviving trustee. Later on, she came back to say that he was actually the first trustee to die, not the last. Now that's important because according to trust law, when there are two or more joint trustees, their power or the power may be exercised by the survivor or survivors. So, or in absence of any survivors, their respective personal representatives are granted this power. So Ms. Archer, correct me if I'm wrong. I essentially took that to mean that because John was not the last or the sole surviving trustee, his powers would not have been passed down to Gladstone, his youngest son, and then by extension, Ms. Saunders, the defendant.
Not if there was a surviving trustee.
So there were at least two other surviving trustees.
Mm. They would take it.
Understood.
Yeah.
All right, so evidence was presented on both sides. The court did say that they favored the plaintiff's evidence, particularly the testimony of his witnesses. So one of them was Ms. Florida Green, who was a former member. She served as the secretary of the union, and she attested that she knew of them keeping all of the records in a glass case inside the building, and that as far as she'd known, you know, almost all of her life being involved in the society, that the building was owned by the Union Society. One of the tenants as well, who I believe was a pastor of a church who used the building twice a week for services, also testified that as far as he knew and understood, the Union Society owned the building as well. All right, so to jump ahead to the court ruling. No, let's deal with the issues first. So on the plaintiff's side, by their statements of facts, the plaintiff claims that the single issue to be decided by the court is whether the legal ownership of the property lies in the plaintiff's or in the defendant. By the defendant's statement of fact, she's claiming that there are several issues to be determined, namely one, whether the plaintiffs are in fact the trustees of the Union Society, and if so, how they were appointed. And if you'll remember towards the beginning of the case, it mentioned where a declaration of trustees dated 2007, naming Mr. Kendall and the other trustees. The second is whether the plaintiffs have standing to bring a claim to oust the defendant from the property. Let me see if I could ad-lib this one. So essentially as a club or an organization, and therefore the trustees acting on behalf of the society. They do have the right to bring a lawsuit such as this one in this circumstance. Am I on the right track, Ms. Archer?
Mm-hmm. Go
Okay.
ahead.
Just making sure. All right, the third issue is whether the Union Society and the Victoria Royal Union are one and the same. That was dealt with pretty quickly based on the, I guess, the history that the court had in front of them. So that really wasn't a big issue when you read the ruling in the case. At least I didn't see it as such. All right. So the court ruling, as I said, the court preferred the evidence of the plaintiff. A couple of reasons that really discredited the defendant. She changed her mind about seeking ownership of the property. There was never any action on Gladstone's part to clean up the title and seek ownership for himself. So they said Gladstone Cerruti had during his life an opportunity to remedy any defects of title to the property if he believed his family had a beneficial claim to the property, but this never occurred until the actions of the defendant, who maintained that she operated on his instructions. Now, Mr. Kendall Marshall in his evidence confirms that he has been president of the society from 1987, when Mr. Gladstone was still alive. And again, no action was taken with regard to the property for the benefit of the Cerruti family. The natural inference, according to the court, to be drawn from this lack of action is the Cerruti family recognized that they had no beneficial claim to the property. In addition to that, there was no evidence that the society did not enjoy undisturbed possession from when it actually first purchased in 1904, straight up until 2006, when the defendant had the current lease tenant removed. The defendant knew that the property was meant to be used for charitable work, but she was using it instead as her own personal living space. And finally, the court decided, after considering all of the evidence and the submissions, that one, again, the Union Society had undisturbed access. Mrs. Cerruti didn't initiate or bring any action as the purported legal owner. The trustee's mandate was and is to hold the property in the interests of the Union Society as the beneficiary. The title documents that were presented, so the deed and the conveyance, confirm the Union Society's undisturbed connection to the property as compared to that of the late Gladstone Cerruti, from whom the defendant seeks to benefit. And the defendant conceded in the witness stand that she did not have a possessory or any title to the property. The end.
Mhm. Now you see how people just squat on
Trust.
land, knowing full well she knew that all
You can't do it though.
on.
What is the last name? Cerruti?
Yes, Cerruiti. There's two different spellings in it, but I think that's the most common one.
I always thought that was the Lodge building. I grew up knowing that's the Lodge building.
Yeah, this
Oh,
is
large building.
Excuse me 1 minute, Ms. Archer. You said Cunell is for me. Cunell, can you repeat the case for me, please?
Quennell versus Maltby.
I don't think she
Versus
got those yet because I didn't see mine.
M-A-L-T-Y.
MAL.
TBY.
PBY. All right, thank you.
Okay. Yes, it was a lodge. Well, like a lodge.
Yeah, but you know, I passed it the other day and I looked at that building and I said, look at this Lodge building, look like squatters on that again.
But it is an historical building.
I remember, because I used to be in the lodge and we used to go there to have our little lodge function.
So you one of the card holders.
Maybe so. I maybe able to go stay claim it.
I don't think so.
Powerful.
I don't think so.
Mm.
But you realize now how many cases we have before the court that relates to land?
Right.
A lot. There was one just in the papers today.
When I did pass that, I said, wonder why the lodge let this building going down like this, not knowing that because it's a legal case.
Yes, it's a battle.
Mhm.
It's a battle in court. All right, so let's turn now to the remedies that a bank has. Did you find Cornell versus Maltby, Zenovia,
Still looking for it.
online?
Yeah, using my phone. To
Oh,
try
look,
and find it.
I don't know if the phone will do the trick.
That's one of the cases that we were supposed to Google it. It wasn't something that Mr. Pratt would have sent, right?
Yeah, you're supposed to Google it.
Okay.
If you just want
Question
to
for you,
yeah.
because I know they had a talk show today and they were talking about, being on person's land, and they said it's 20 years if it's government land, and if it's personal land, it was 12 years. I was thinking it was 20 years irregardless. So is that the case?
20 years if it's government land.
Yeah, Crown land. What the guy name? He has a talk show. He was saying if it's government land, we be on it 20 years, they can't bother with you no more. And if you be on personal land, 12 years or more, then they can't bother with you, because they were talking about, different things happening in the Bahamas and what's not. Auckland Bodie is his name.
Mm-hmm. No, I got
So is that true? Because I was thinking it was 20 years across the board.
No, it ain't 20 across the board. I know it's 12. But most of the matters
Also,
come what have to do with personal land. So he probably talking about he's talking about Crown land and shanty towns.
Now,
Like
Ms.
which
sorry.
land is he talking about? Uh-oh. I can't hear her.
I said, can you hear me now?
Yeah, I can hear you now. Go ahead.
Yes, they were just calling in saying, how come Bahamians can't be on the land, but foreigners can be on the land. And he was saying, my brother, this is the law. And he was saying 20 years if it's Crown land. So I think foreigners were involved. And he was saying 12 years if it's personal land. So that is correct?
I might have to look that up. That must be a different legislation. I don't
Okay. But I mean, in general, from what we've been learning, I thought it used to be 12 and it's now 20.
No.
We did 12 when in the first, was it first chapter we did? 12 years
personal
adverse possession.
and 30 years for Crown, 60 if it's beachfront.
So it's 20,
So
12.
12 for personal, according to the notes, 30 for Crown land, and 60 years if it's beachfront, Crown land.
Oh, I have to, okay. All right. I mean.
So what was their argument now? What was the gist of the argument? That these people can stay on the land, that they can claim it?
Can you, Ms. Archer, if they don't have, if they're not citizens or residents? Can
No.
illegal immigrants do that?
No. But the thing about it is that they don't want to address the issue.
Right.
You have to take the bull by the horn and address the issue. Because even though they are illegal and on the land, when that time comes, I'm sure someone legal will say that they were there. Think about it.
Yes.
Ms. Archer, what was the reason behind, I didn't read the entire case, the reason behind the judge's ruling that when they had to stay on, they had stay orders for the government when they were trying to demolish those shanty towns. They told them that they couldn't do it. They just recently lifted it. and told them that they could resume. But what was the reason for them not allowing them to continue at that time?
That I have forgotten.
I think they said COVID.
No.
It had something to do with, I think it had something to do with the rights, people rights, and in this COVID environment, something that affect when they did the state.
I don't
Okay.
remember
Said,
that.
I have
like
to
you
look
can't
that
put
up.
people out. You can't put people out during a pandemic. That's what it had to do with. They considered it
Oh,
was a
okay.
pandemic.
Let me see. Court.
That sounded like more of a political thing than a
It's more
legal
political.
thing.
Yeah.
That's how I felt going into elections. Huh?
Hold on, let me see something. Because that's why I say they don't deal with the issue.
No.
And it's getting worse now.
Oh yeah.
It's worse. Okay, let me see. So the injunction was granted in 2018. Isn't that before COVID?
Right. COVID was
Yeah.
2020.
Okay. They were going to evict 177 residents. Cheryl Grant Bethel said the court is satisfied that the minister has the authority to remove or require removal of dangerous or dilapidated buildings, even to the point of demolishing them. Such structures would obviously pose a risk to the health and safety of the public. And as a result of this ruling, the injunction, which was in place covering the shanty towns, is hereby discharged.
But why it was put in place to begin with in
That's what I have
2018.
to find. Yeah, that's what I have to find out. Because it ain't saying nothing about
That
that.
was just okay.
Okay.
So that was 2018. Let me see if I could find that.
But then Michelle, who lifted it? I mean, she put the injunction in place and lifted it.
She did?
She went back and reversed the ruling, eh? I think they went
Yeah,
back to court.
you just said she put it in place in 2018. It was
No,
no
I
jurisdiction
say
on
no.
Friday.
I say it happened in 2018.
Oh, okay.
Yeah.
Okay.
It just say she lifted
She
the
lifted it, yeah.
injunction.
Yeah. I know she was the one that lifted it.
Yeah, let me look and see if I can get injunction. (2018) all they keep talking about is lifting it. I have to look for that. Let me see something. Shantytown. Hold on. Shantytown injunction disturbing. Shantytown Committee Chairman Senator Dion Folks has been given firm instructions despite the Supreme Court granting an injunction blocking the demolition of shantytowns in the capital. So the opposition was saying that the injunction was made without the Crown, like a representative from the government being there. And that's it. I can see if I can find the actual case. So that was 11 shanty towns that they placed the injunction on. 5 in Abaco.
My Lord.
That was even before Dorian, so it can't even be because of
Yeah.
that.
Because this article was written the 8th of August 2018 in the Bahama Journal. And I don't even think they print that anymore. So there was an injunction blocking the demolition of shanty towns in the capital. Mm-hmm. But I probably have to see what the court said, the reason why they wanted to stop it. Yeah. So they made a decision with the injunction, and they did it ex parte. That means that no representative from the government was present when the decision was made. Then that is very strange.
Yep.
I'll look it up. I'll look it up and we'll see. I don't remember who made the decision. But I probably have to go. I'm looking it up on my phone. You know, the phone is very limited. I'll go on my main computer. All right. So y'all give me homework. Someone was going to say something.
I was gonna question going back to the case with the lodge. If
Mhm.
there were other trustees who were alive, how was it that the lady was able to go ahead and put in a claim saying that she was the rightful owner, knowing full well that there were other trustees? And
That's why she changed her story.
Okay.
I'm saying that she owned it and that she was just there more or less like so she was preserving it. Knowing that she changed it. She knew full well she had no ownership rights to that.
Not a crook.
Yes, but if you can get away with it, you can.
Yeah, because if she had gotten documentation and papers, that would have been it.
Yep. She was, and you see how far back she was tracing it.
Yeah.
Yep. When you start to read the matter, you would swear that she actually have rights.
Mm-hmm.
She had a story down back, but that's just how they are.
She seemed to have been treating that property initially
As
as
it-
though this was property being passed down like intestate
Mhm.
through the will. Like she said she was trying to say that she had a claim because Gladstone's father was one of the original trustees, so that gave him rights, and then by extension, when she was given the power of attorney and then made sole beneficiary of his will, now she herself has a claim. But her story contradicted itself in several key ways.
Yeah, she no. I don't even understand why she bothered to go to court. Waste of time.
Yeah, that was a waste of time and money.
Yeah, our money.
Yes.
Okay, so now you find Cornell.
I can't find it. Quenelle. I can't find it.
Quennell versus Maltby.
Quennell.
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 Space for the
Quennell versus
Maltby. Maltby.
Is that Quennell versus Maltby 1979?
79, yep.
Okay.
Okay, give me a few minutes. Can someone else go while I do this? Y'all don't mind?
Yeah, someone else can go. Stacey, you want to do Baxter?
Okay, so you now, because I just Googled this, you want me to more or less just read what they have here
Yeah.
quickly?
I
Okay.
said these are easy.
Not a problem. Okay, so
Here it is.
Baxter versus FW Gap and Co. Limited, 1938. Is that the correct one?
Yes.
Okay, King's Bench Division, Goddard LJ sitting as an additional judge. And it was heard on the 9th, 10th, 11th, 14th, and 16th of November, 1938. Agency, professional agent, duty to use care and skill, valuation of property, advance by way of mortgage on footing of valuation, negligence, knowledge of locality, reliance upon valuation, measure of damages. The case is the defendant and a state agent was sued for negligence in making a valuation of property for the purpose of an advance by way of mortgage. It appeared that the defendant inspected the property but failed to make any local inquiries as to the value of that or similar properties in that locality. The defendant had not practiced in the locality. The defendant also failed to inquire the price the property had realized upon recent dealings. The valuation was £1,800. The property had been purchased by the mortgagor for £600, and the highest price at which it had changed hands in recent times was £850. Certain additions and alterations to the property were, at the time of the valuation being made, and the defendant advised an advance of £1,200 upon first mortgage, subject to £200 being retained pending the completion of the additions. The defendant subsequently advised an advance of £150 on second mortgage. This valuation was given to the plaintiff's solicitors, who subsequently discovered the price the property had realized in recent transactions, and also received the suggestion that the value was too high from a local agent. It was held that the defendant must be taken to have held himself out as possessing the necessary experience and skill to value this particular property. His knowledge of property in the locality was insufficient, and he ought to have taken steps to inform himself of the value of similar properties there, which he had failed to do. The facts did not support a contention that the plaintiff had not relied upon the defendant's valuation. The measure of damages was the whole loss sustained by the plaintiff and included the expenses of the abortive sales, insurance premiums, builder's account for upkeep of the property, mortgagee's expenses and disbursements, and the agent's commission upon the ultimate sale of the property, in addition to the principal advance and the interest unpaid. The judgment herein discusses at length the duty of a professional man called upon to give professional advice. The particular profession in this case is that of estate agency, but in a general way, the same principles apply to other professions. The facts of the case entail a consideration of the duties of an estate agent when called upon to value a property outside his own area and in a district in which he has had no previous experience of the valuation of properties. The judgment concludes with an examination of the measure of damages in such a case, and in general decides that all the expense and loss to which the mortgagee has been put or which he has suffered are to be included in the assessment. Okay, and
Okay.
it refers to some cases. Mhm.
And that was simple, right?
Yes, ma'am.
Mhm. So you understand now when you get a property appraised and it's time for the bank to sell, when they say that if a person has never done an appraisal on a particular area, this case lays out duty and what they should do in valuing the property. Because you can't say you have certain experience and skill that you don't have. Because you could be sued.
Right. I know that the bank has a listing of approved appraisers, and
Mhm.
on that list, they even indicate which island they are authorized to provide an appraisal for, and they even give a dollar amount. So if an appraisal is over a certain amount, they won't take it from a particular appraiser. They'll have to go to an established company.
Mm-hmm. And that would be based from this case
Right.
from
And
1930.
one of the things I noticed that they require comparative sales values within that appraisal, because I noticed one of the things they said is that he had no idea of how much properties in that area were
Mhm.
sold for. So when he made his valuation, he just was going off the top of his head, and some of the properties in the area were sold for much less than the value that he put on that particular property.
Mhm. See, he says here the plaintiff case is you advised £1,800 on the value of this house. That is the sum which you put upon it, and that was your valuation. I say that was a negligent valuation because the house was never worth £1,800 and was not worth anything like £1,800. You could not have exercised due care and skill in coming to that conclusion. It would be enough for the plaintiff to take up that line and to say, I'm going to show by the evidence of experts and others that at no time could any reasonably careful valuer have said that £1,800 was the value of the house. And that's why you see over time, these procedures and processes come into place. And all of it is to mitigate against such risk, as found in the case of Baxter. So now you have an understanding why there is a list.
Right. And they also have to state in the almost like the first or second, like the second page, that they know the reason they're preparing it, that it's for the bank and for the purposes of offering finances. So you can't come back and say, well, my values weren't because I know that you were going to be, financing a mortgage or so forth.
Yes. But you know what? It's not a list just for list's sake. It's for the bank to mitigate against the risk of being sued, that the valuation of the property is not what it should be. Okay. Thank you very much, Stacy.
You're welcome.
Marissa, you want to do Park?
Miss Archer, I was trying to locate it. I found a case, but I'm not sure this is the correct one.
What
Quick
is talk?
question, are we using the cases that Mr. Pratt would have sent us last week? Or are we just going based on what you would ask us to look up?
We're doing both.
Okay.
So right now, Katora, you'll be next. You'll do Sylvan, and that's straight from the internet. And
So,
from Mr. Pratt, we'll just look at some of the short ones. Not all of them.
SYLVIN?
Yes, Sylvan, SILVEN Properties versus Royal Bank of Scotland. Okay, Marissa, you have Parker.
Okay, so the case that I'm looking, that I found is Barry Parker Tweedale
Versus Dunbar.
plaintiff and Dunbar Bank PLC and others. Appellant, first defendant. That's correct?
Yes, that's correct.
Okay, and Annabelle Teresa Parker Tweedale, respondent, third defendant. Okay, and this case is heard before Mr. T. Lloyd QC and Mr. Stephen Action, instructed by Messrs. Clintons. Prepared on behalf of the appellant, first defendant, Mr. Stephen Whitaker, instructed by Messrs. Baldock's, Guildford, appeared on behalf of the respondent, third defendant, Mr. Hugh Summerfield, instructed by Messrs. Philip Ross and Co., appeared on behalf of the second defendant. And the case is heard before Lord Justice Norse. So in Parker Tweedale versus Dunbar Bank, PLC and others, the 14th December 1989, we decided that a beneficiary, even a sole beneficiary, under a trust of which the mortgagor is the trustee, is not the neighbor of the mortgagee. Now, in determining whether the mortgagee's cost of successfully resisting the beneficiary's action can be added to its security, we must decide whether the beneficiary is also a stranger to the mortgagee. Okay, the determination is made necessary by a cross appeal brought by the mortgagee, the first defendant, Dunbar Bank, against a declaration made by Peter Gibson J. on the 9th of August, 1989. There being no reasonable prospects that the plaintiff will meet the orders which have been made against him, Dunbar seeks to add its cost of the proceedings to its security. The judge held that it was not entitled to do so. The contest now is between Dunbar and the third defendant, Annabelle Teresa Parker Tweedale, the wife. The disastrous consequences to her of the appeals being successful were referred to at the end of my earlier judgment, since when up-to-date figures have shown that although there might still be some surplus to go towards paying off the mortgage on Wilkes, it would fall far short of discharging it. So in essence, the funds would not cover the full amount of the loan, the mortgage, so that the future security of the wife and the two children at Wilkes would still be at serious risk. But the sympathy with the wife, which even a most cursory view of the facts will naturally generate, cannot enter into a determination of a question of law in which the general merits of the case have no part to play. Sorry, give me just a second. As a matter of contract, sorry?
No, I was telling Ms. Arch, I just sent a message. Sorry.
Okay.
Okay.
As a matter of contract between Dunbar and the wife, Dunbar's entitlement to add its cost to the security is governed by Clause 21 of each of the three legal charges, which, so far as material, is in these terms. All costs, charges, and expenses properly incurred hereunder by Dunbar and all other monies properly paid by Dunbar in respect of the said charges, cost charges, and expenses, or otherwise together with interest thereon as aforesaid, shall be charged on the mortgage premises. Both sides have throughout accepted that this provision was intended to apply to the cost, charges, and expenses recoverable by the mortgagee out of the mortgaged property under the general law, neither more nor less. It is therefore to the general law that we must look. Any dispute as to the cost, charges, or expenses which ought to be allowed to a mortgagee is usually determined on the taking of an account between him and the mortgager. But where an allowance is claimed for the cost of other proceedings to which the mortgager is a party, it is obviously convenient for the claim to be dealt with, as it were here, by the judge who has tried those proceedings. Be that as it may, it must be borne in mind that the claim arises not out of the proceedings, but out of the relationship of mortgager and mortgagee, and without any express contract between them. Okay, a mortgagee is allowed to reimburse himself out of the mortgage property for all costs, charges, and expenses reasonably and properly incurred in enforcing or preserving his security. Often the process of enforcement or preservation makes it necessary for him to take or defend proceedings. In regards to such proceedings, three propositions may be stated. One, the mortgagee's cost, reasonably and properly incurred, of proceedings between himself and the mortgager or his surety are allowable. The classical examples are proceedings for payment, sale, foreclosure, or redemption. But nowadays, the most common are those for possession of the mortgage property, preliminary to an exercise of the mortgagee's statutory power of sale out of court. Two, allowable also are the mortgagee's costs, reasonably and properly incurred of proceedings between himself and a third party where what is impugned is the title to the estate. In such a case, the mortgagee acts for the benefit of the equity of redemption as much as for that of the security. 3. But where a third party impugns the title to the mortgage, or the enforcement or exercise of some right or power accruing to the mortgagee thereunder, the mortgagee's cost of the proceedings, even though they may be reasonably and properly incurred, are not allowable.
Mhm.
These propositions being drawn from two lines of authorities decided between 1802 and 1936 may reasonably be thought to have become a matter of settled law. Moreover, the third of them would appear to be directly applicable to the present case, where a plaintiff who was not the mortgager impugned an exercise of the mortgagee's statutory power of sale. But Mr. Lloyd for Dunbar has urged us not to apply it. He has put the case in several different ways, relying partly on an argument based on RSC Order 62, Rule 6.2, which was not advanced in the court below. The first and second propositions have together been called the general rule. The third has been called the exception to it. The diligence of counsel, having guided us through many of the authorities on the general rule and all of them on the exception, it is only necessary to refer to the more important of them. The principal decision which supports the general rule are those of Lord Ellen LC in, Lord, bear with me on these names, Dettelin versus Gale, 1802, of Lord Cottenham,
Cottingham.
LC, Cottenham, in Dryden versus Frost, 1838, and of this court, Cotton, Bowen, and Fry,
Oh, Lord.
Who falling out?
I know. National Provincial Bank of England versus Games, 1886.
You ain't gotta call all them names.
Okay, there's plenty. The
Cause
principal
they
decisions which support the exceptions are those of Sir William Page Wood, in Owen versus Crouch, 1857. Okay, and there's a lot more to follow. The decision of this court, Lord Wright, M.R., Rumer and Green, LLJ, in Re Layton's conveyance, supports both the general rule and through the observations of Rumer, L.J., the exception. The material facts of Owen versus Crouch and Parker versus Watkins are summarized in the judgment of Eve J. in Re Smith's Mortgage, 1931. Here it is desirable that they should be stated as simply as is reasonably possible. In Owen versus Crouch, a mortgagee who had evicted some lodgers installed in the mortgage property by one of his neighbors was not allowed to reimburse himself for the cost of successfully defending an action in trespass brought by the neighbor, who had also committed an assault. In Parker versus Watkins, Mrs. Eaton, the tenant for life under a settlement, unsuccessfully sued for a declaration that the settled property did not stand as security for the trustee's cost of raising on mortgage a sum which had been duly appointed under the settlement, as distinct from the sum itself. On Mrs. Eaton's failure to comply with an order that she should pay the mortgagee's cost of the suit, he claimed to reimburse himself out of the settled property. It was held that he was not entitled to do so. In each of these cases, Sir William Page Wood v. as he usually did, delivered an extempore judgment. What is an extempore judgment? Okay. In Owen versus Crouch, he said, this violent neighbor chose to bring an action of trespass against a mortgagee with as much reason as he might against anyone then in court. Was the court to fasten upon the mortgagor the consequences of this action? It was contended that if the mortgagor had paid the defendant at the proper time, there would have been no action, but this applied equally to the assault or any other possible collateral damage arising from this inconvenient neighbor, which could not be fastened upon the mortgagor, who was only liable for any charges incurred in a just protection of the property. These costs did not come within that category, and they could not be allowed to the mortgagee. In Parker versus Watkins, 1859, the vice chancellor, having said that he did not see how the mortgagee could have his costs against the settled property, continued, I quite agree that where a mortgagee has been put to expense in defending the title to the estate, the defense being for the benefit of all parties, he is entitled to charge those expenses against the estate. But if some litigious persons chooses to contest the mortgagee's title to the mortgage, that should not affect the party's interest in the equity of redemption unless they can be shown to have concurred or assisted the litigation. It is the ordinary case of anyone who has the misfortune to have dealings with a litigious person who is unable to pay the costs occasioned by his conduct. So that wraps.
That's enough. They can go to sleep.
Huh?
That's enough. They'll go to sleep. They could
Yeah.
redirect on.
It told me I need to continue reading request my trial of what?
Your trial is finished. They only give you so much. You don't get a lot.
Oh, okay.
Yeah, they don't give you the whole thing. They only give you a piece.
Oh my, wow. Okay. So I don't know how it ends.
You don't know what was held?
How it ends. I mean,
The Dunbar Bank appeal was dismissed by the court.
okay.
And the decision that was made in the first court was affirmed. So the court said, in circumstances where a third party created a claim that wrongfully questioned the mortgagee's right in relation to a property, it's not appropriate that they are reimbursed from the mortgaged property.
Okay.
And it said it's also the case where the third party stands to gain from raising the question in the first place. That was Parker, Tweedy versus Dunbar. You found Quinnell on Maltby. Zenobia, you found it?
I found it. I have two things in front of me, but I just want to ask a question, please, before I start.
Go ahead.
Because sometimes I notice like the dates would be different, right? So you would have a date and then you will have this ER 568. What is the ER 568?
ER, that's the English Law Reports, page 568.
Oh, okay. Okay.
That's
So that's telling you.
Yeah.
So does the dates make a difference? Because sometimes I notice like some of the cases would come up with different dates. Does that make a difference? No?
Depends on which book is being reported from.
Okay. All right. So
Yeah.
that's what that is
And
about.
sometimes the date, if the dates are like a year between or 2 or 3 years, sometimes it will be the decision from the first court versus decision from the second court.
Okay. All right.
Yeah.
So understood. So I don't know. Maybe this was
Ms.
the right
Archer,
case.
before you start,
Yes.
Sylvan, I sent you a message, but I don't think you got it. This,
Sylvan?
yes, versus who?
Sylvan versus Royal Bank of Scotland.
Royal Bank of Scotland. Okay, thank you.
Can't miss it.
Okay.
Famous.
Good night, Ms. Acho.
Yes.
Yeah, I'm just looking through my emails. I don't think I received the list of the English cases that you listed for everybody to look at. So I don't know if you could probably just forward that over to me so I can
You mean the English ones? No, the English ones, you remember I told you breaking up. Yeah, you break
Again?
you break it up. I could send it to you sometime tomorrow.
All right, that'll be fine.
Yeah.
Tomorrow's fine.
Okay, Synovia, come tell us about Quinnell versus Maltby. That's a quick one.
Good thing. I hope this is the right case. Does it have to do with Mr. Quinnell is a gentleman who lives in London?
Yes.
Okay, but he's the owner of a large house in Louise.
Mm-hmm.
I could skip out some of this. Okay, yeah. So it has 9 bedrooms. He has an agent who looks after the home for him. The house is a house very suitable for students. In 1973, the agent rented it out to some students of a university. Two of them became tenants. They were Mr. Maltby and Mr. Jack. They were let into possession for a term of 1 year at a rent of $90 a month, expiring December 31st, 1974. They had other students there with them, about 9 students in the house. While Mr. Maltby and Mr. Jack were tenants, Mr. Quinnell borrowed money from Barclays Bank and mortgaged his house to secure the loan. It was only for the sum of $2,500. He executed a legal charge on August 13, 1974 in favor of Barclays Bank to cover any monies which might from time to time be owing to the bank. In that legal charge, there was this clause, and the clause is as follows. During the continuance of this security, no statutory or other power of granting or agreeing to grant or of accepting or agreeing to accept surrenders of leases or tenancies of the mortgage property or any part thereof shall be capable of being exercised by the mortgagor without the previous consent in writing of the bank. That meant thereafter from August 13, 1974, so long as this legal charge subsisted to the bank, Mr. Quinnell could not let the premises or accept surrenders without the consent in writing of the bank. The tenancy of Mr. Maltby and Mr. Jack came to an end at the end of December 1974. The house was then relet to 2 other students, Mr. Quilter and Mr. Leaf, again for a year. It was not relet to Mr. Maltby because it was thought that he was going to the United States. As it happened, Mr. Maltby did not go to the United States. In fact, he stayed on living in the house. So did several other students. At all events, the important thing to note is that the bank did not give its consent to this letting to Mr. Quilter and Mr. Leaf. No one asked the bank for its consent. No one realized it was necessary. No one interfered and nothing happened. The year 1974 passed. Then at the end of that year, pardon me?
The year 75 passed.
Yeah, the year 1975 passed. Then at the end of that year, there was a fresh letting. This was between Mr. Cunell as the landlord and Mr. Mulberry and Mr. Lupton as tenants. The tenancy lasted until December 1976. Again, no one asked the bank for its consent. No one realized it was necessary. And from January 1977 onwards, the tenants remain as statutory tenants, paying the rents to the agents. The position then arose that Mr. Cunell wanted to get possession of the house. If he could get vacant possession, he could sell it at a high price. It might be worth $30,000 to $40,000 with vacant possession. Mr. Cunell started proceeding for nuisance and annoyance, but he dropped them. Then he went to lawyers for advice. After consulting them in October 1977, Mr. Cunell went to the bank and told them about the tenants in the house. The bank had not heard before about the various changes in tenancies. Even when they were told, the bank made it clear that they had no intention of taking any proceedings to enter the property or to turn the tenants out or anything of that kind. The banks were not concerned to get possession. Then Mr. Cunell lawyers in London advised him that there was a good way in which possession could be achieved. This is what it was. Mr. Cunell's wife, Mrs. Cunell, paid off the bank. She paid the $2,500, which was owing to the bank, and took a transfer of charge. The bank transferred it to her by a transfer date, January 17, 1978. Then Mrs. Cunell brought proceedings against the tenants, Mr. Mulberry and Mr. Lupton, seeking possession. She said that she stood in the shoes of the bank and seeing that the tenancy was granted without the consent of the bank, it was void. So she could recover possession. The judge accepted this submission. He held that the wife, Mrs. Cunell, was entitled to possession of the premises and could turn Mr. Mulberry and all the other students out of the house. Now it had been held that when the bank holds a charge and there is a clause in it whereby there are to be no tenancies granted or surrendered except with the consent of the bank in writing, then in those circumstances, if the mortgagor does therefore grant tenancy without the consent of the bank, those tenancies are not binding on the bank, and the tenants are not entitled to protection of the Rents Act. That was decided in Dudley versus District Benefit Building Society versus Emerson, 1949. Oh, I didn't have to say that. Mrs. Cunell relies on that case. She says that as transferee of legal charge, she stands in the shoes of the bank and can obtain possession. Oh, I said it. I finished it.
Already read that.
It's yeah, that's a repeat. Yeah, she already paid off the bank. That was indeed what happened. Yeah, so I finished because this seems to be a repeat. What is this last piece saying? Let me just read the last one then. That was indeed what happened here in 1977 when Mr. Cunell went to the bank. He told them about the tenancy. They said that they did not intend to take proceedings, so he got Mrs. Cunell to do it. In evidence, she said, I paid $2,500. This was for my husband. I took the charge to make the debt to the bank less, onerous. I was aware he wanted to obtain possession of the house to sell it. I merely paid off the charge. These proceedings have been brought to get possession to sell. So the objective is plain. It was not to enforce the security or to obtain repayment or anything of that kind. It was in order to get possession of the house and to overcome the protection of the Rents Act. Is this permissible? It seems to me that this is one of those cases where equity steps in to mitigate the rigor of law. Long years ago, it did the same when it invented the equity of redemption. I don't need to read that piece. The courts left the legal effect of the transaction. Okay, I don't need to read that. That's a part of a case. So here in modern equity can step in so as to prevent a mortgagee or a transferee from getting possession of a house contrary to the justice of the case. A mortgagee will be restrained from getting possession except when it is sought bona fide and reasonable for the purpose of enforcing the security, and then only subject to such conditions as the court thinks fit to impose. When the bank itself or a building society lends the money, then it may well be right to allow the mortgagee to obtain possession when the borrower is in default. But so long as the interest is paid and there is nothing outstanding, wow, equity has ample power to restrain any unjust use of the right to possession. It is plain that in this transaction, Mr. and Mrs. Cunell had an ulterior motive. It was not done to enforce the security or due payment of the principal or interest. It was done for the purpose of getting possession of the house in order to resell it at a profit. It was done so as to avoid the protection which the Rents Act affords to tenants in their occupation. If Mr. Cunell himself had sought to evict the tenants, he would not be allowed to do so. He could not say to the tenants, he could not say the tenancies were void. He would be stopped from saying so. They certainly would be protected against him. Are they protected against his wife now that she is the transferee of the charge? In my opinion, they are protected for this simple reason. She's not seeking possession for the purpose of enforcing the loan or the interest or anything of that kind. She is doing it simply for an ulterior purpose of getting possession of the house, contrary to the intention of Parliament as expressed in the Rents Act. On that simple ground, it seems to me that this action fails and it should be dismissed. The legal right to possession is not to be enforced when it is sought for an ulterior motive. I would, on this account, allow the appeal and dismiss the action for possession. Agreeing, Bridge L. I don't even know. The situation arising in this case is one, it seems to me, in which the court is not only entitled, but bound to look behind the formal legal relationship between the parties to see what is the true substance of the matter. Once one does that, on the facts of the case, it is plain as pikestaff that the purpose of bringing of these proceedings via Mrs. Cunell is not for her own benefit to protect or enforce the security which she holds as the transferee of the legal charge, but for the benefit of her husband as the mortgagor, to enable him to sell the property with the benefit of vacant possession. In substance, she is suing as his agent. Oh, sorry, this thing just dropped. In substance, thing just dropped.
That being so, it seems to me inevitably to follow that she can be in no better position in these proceedings than her husband would be if they had been brought in his name. Now, remember now, he took this route under the advice of who? Who gave him this advice?
His attorney.
His attorneys gave him that advice.
Yeah.
His attorneys gave him that advice. The other justice in this matter, he said, as I say, the authorities established this as a matter of law. A lease made in breach of covenant by a mortgagor is void against the mortgagee. And I assume for present purposes against the transferee, unless the lease is adopted by the mortgagee. So neither the bank nor the wife adopted the tenancy. The estate, rights, and powers of a mortgagee, however, are only vested in a mortgagee to protect his position as a mortgagee and to enable him to obtain. Subject to this, the property belongs in equity to the mortgagor. In the present case, it is clear from the facts and the evidence that the mortgagee, Mrs. Quinnell, is not bona fide exercising her rights and powers for her own purposes as mortgagee, but for the purpose of enabling the landlord mortgagor, her own husband, to repudiate his contractual obligations and defeat the statutory tenancy of the tenant, which is binding on the landlord. Mrs. Quinnell does not even pretend to be acting in her own interest as mortgagee. She brings this action to oblige her husband. In my judgment, the court must therefore treat this action, although in form brought by a mortgagee, as an action brought forth on behalf of the landlord mortgagor. The court should deal with it as though the mortgagor landlord were the plaintiff, and on that basis, possession will not be ordered.
I was confused as to how she could represent the bank though.
In her mind, that's what the lawyers told her.
But she won the first time. It's only on appeal that they overturned it. It worked in the first instance.
That was
But
confusing.
we notice a lot of things work in the first instance.
Yep.
Okay. But you see the approach with when they go to the Court of Appeals, you see the approach they take similar to our Court of Appeals, they take a different approach.
Wow. So that means
Hold on, you get cut off. What happened?
does that means at the end of the day, they couldn't get access to the building until the lease expired? Yeah?
Mm-hmm. Yep.
Oh, okay. All right.
And
What was that?
again, when you have a mortgage, and you read the deed, you really have to read those covenants that are in there. They're put in there for a purpose.
Yeah.
Someone was going to say something just now.
My apologies, yes. What I started to
Go
say
ahead.
when you mentioned the lease expiring, I think something was mentioned that the lease came to an end, but they became statutory tenants. What I was about to Google it to see what was the difference.
Which paragraph that was in now?
1 second.
Where is it with the statutory tenants? 1976, 77. I don't have that highlighted on my
18. I think 18, the landlord being unable to get possession from his own statutory tenants approached the bank. The lease to statutory tenants was made by the landlord after the date of the mortgage without the consent and something else.
I think it
7.
started in
Which
number
paragraph 7?
17. It started in number 17, just before that.
17? Okay.
The lease to the statutory tenant was made by the landlord.
Okay.
Because doesn't he come under the Rent Act? as a tenant.
Sorry, say it again.
I said as a tenant, they would have been covered under the Rent Act,
Yes.
right? And so the Rent Act would be a statutory document. So that's why they call them a
Okay.
statutory tenant.
Okay.
Yeah. Because their rights will be under the Rent Act. Okay, do we have time for Sylvan Katora?
Not sure if I pulled up the correct thing,
Okay,
but
we'll find.
I will attempt.
Go ahead.
Okay, Sylvan Properties Limited versus Royal Bank of Scotland is an English land law case concerning the behavior of receivers appointed under mortgages. Now, 1 second for me. Just bear with me 1 minute. Okay. Now, how this is set up, it has the facts, the judgment, and the impact. Can I
Okay,
go
go ahead.
ahead?
Mm-hmm.
Okay, Sylvan Properties Limited versus Royal Bank of Scotland is an English land law case concerning the behavior of receivers appointed under mortgages. It affirmed the proposition that a lender and its agents or receivers are not required to incur expenses that would likely delay a sale beyond the normal period of marketing. The facts: in 1996, Royal Bank of Scotland appointed receivers over 33 properties mortgaged by Sylvan Properties to it and proceeded to sell them off. The receivers explored planning and letting out the properties, but decided to sell them straight away. Sylvan alleged that RBS's receivers were under a duty to maximize the value by getting planning permission for development and letting out of vacant properties. In the Chancery Division, Patent J held that neither the mortgagee nor receiver were required to incur expenses that would likely delay a sale beyond the normal period of marketing. This was supported by the case of Cookmere Brick Co. versus Mutual Finance, Downsview Nominees Limited versus First City Corporation Limited, and Medforth versus Blake. The judgment, Lightman J held that RBS had not breached its duties. A duty is owned in equity rather than tort, but it was not breached on the facts. 1, the mortgagee is entitled to sell the mortgage property as is, but is under no obligation to improve it or increase its value. The mortgagee is free in his own interest as well as that of the mortgager to investigate whether and how he can unlock the potential for an increase in value of the property mortgaged, but he is likewise free at any time to halt his efforts and proceed instead immediately with a sale. If the mortgagor requires protection in any of these respects, whether by imposing further duties on the mortgagee or limitations on his rights and powers, he must insist upon them when the bargain is made, and upon the inclusion of protective provisions in the mortgage. The one method available to the mortgagor to prevent the mortgagee from exercising his right is to redeem the mortgage. And then the impact on that, Sylvan's reasoning was also held to apply to other forms of mortgages in Den Norsk Bank, ASA versus Ace Max Management Company Limited, which was handed down several days after, as Longmore LJ noted in his ruling. These statements of the law cannot be sidestepped by saying, in the case of a movable chattel, such as a ship that the mortgagee has to take care to sell at the place where the best price is available, because to transfer a chattel from one place to another will inevitably take time and mean that the sale is deferred. It is entirely different from a case where a short delay is appropriate for that a property can be properly advertised. The position might not be the same in cases where there is no true market for the chattel concerned at the place in which the mortgagee possesses to sell. It might, for example, be inappropriate to sell a valuable picture in Panama rather than in a recognized center for the marketing of pictures. But even then, there would be questions about the cost of transport, which would have to be resolved.
Okay. So now we've been around and looked at how many? 2, 3, 4 cases in addition to in the manual with regard to remedies. And you see how important it is when someone gets a mortgage, that they understand what those provisions are in the mortgage deed.
Yes, ma'am.
It's very, very important. So when you look at Module 5 speaks about the mortgage's duties, the liabilities, and its rights. Some of those cases just spoke of, Crookman Downsview. Those are 2 cases that you also need to read. Again, you just need the summary that's that's online. You don't need to pull the full thing.
Okay, I'm gonna look those up.
Right. So we know that the primary obligation of the mortgagor is to repay. And they have to repay the amount, principal, interest, and any sums that are owing. And then once he fails to pay, the mortgagee has the right to pursue the legal remedies that we discussed last week. Because then they're going to be in breach of the contract.
Yes, of the contract.
So in most instances, the mortgagee is likely to exercise their statutory and contractual power of sale and sell the mortgage property. And in the past couple of years back, a lot of the mortgagors were making noise about the mortgagee exercising their power of sale. And then that came out with the Homeowners Protection Act. Has everybody read that? Or do I need to send that?
You could send it.
Send it, please.
Okay.
Ms. Archer, in addition to that, I guess the cases or the list of cases that we have, like looking to look up and read the summary and stuff like that, did you already put a list of those together?
For our next class?
Well, I mean, even the ones we did tonight.
Yeah, I told you I have an email with the ones we did tonight and the cases that I sent. But I'll send it to you all.
Thank you.
Yeah. And then the cases from tonight, I'll send those to you also. I'll see if I can get the links and send the links for them.
All right.
Okay. Question. So the midterm is still on the 20th?
What the day is? 13th? Yeah. Oh, hold on. Let me see if he answered me. 6 p.m.
Okay. So that will be in person?
Yes.
Did you find out about Freeport, Miss Archer?
He didn't say, so I'm asking right now.
Okay.
Both Nassau and Freeport to see what he says.
And this is the BIF headquarters on Shirley Street, right?
Yes, ma'am.
Okay.
And Freeport is the mechanic shop, right?
Mechanic shop?
That's what he sent to me. I sent him an email.
Okay, hold on. He
asking-
said yes for Freeport at 6 o'clock. Let me ask him
Ask him
where. in
where.
Freeport.
Krista, I sent you a message. Look at it for me, please.
All right.
Ms. Archer, quick question. Any past papers or past exams that might be available for us to look at as like practice?
Now, don't forget now. You all have, I don't know if you were there, Fountain, when they were arguing that they want multiple choice.
Yeah, I recall that.
No, I don't have multiple choice as past question. I can give you short answer questions, but multiple choice.
I'll take
You
the
could
short
send us-
answers.
I'll take the short
any
answers
consecutive.
too.
Whatever
Okay.
we could get, we'll take.
Yes.
Our
Definitely.
exam is,
Midterm is no need to stress. You stress when
our exam is supposed to be split between the two, right? Multiple choice and short answers.
yes. And it's only midterm. It's only 5 chapters. We all stressing.
Only
Lord.
midterm, but that's 50% of our grade, right?
I think so. What I mean, you know,
Yeah, not stressing. We just want to make sure we get this thing right.
you can get it right if you study properly. You'll get it right. So you want me to put chapter 5 in it, or leave 5 to go with 6 for the final? Because remember, I was telling you 5 has to do with the mortgagor's duties, and then 6 has the mortgagees. So they go like hand in hand.
Leave them
I
for
think we
after
should
that.
leave that soon that we just starting it. And then we have in the midterm on Monday, which is like a few days away.
I agree. So both of them go hand in hand for the next exam.
Yeah, they go
Yeah.
hand in hand along with the mortgage deed itself. Like I could take a provision out of a mortgage deed and then create a scenario question. Yeah, rather than separating it.
Ms.
That's
Archer, I
fine.
think they're saying go for 1 to 4.
Yeah.
Yeah, go from 1 to 4. So once we start on the mortgagee and mortgager, we could have all of that at one time so we could get a better understanding as opposed to starting this piece now
Right.
and then,
2 weeks and then getting back to it.
yeah.
Okay,
Agreed.
so let me send you the links for module 5. Hopefully I can find them. And then Homeowners Protection Act.
Yes, please.
Miss Archer,
Yes.
how much multiple choice and how much short answers would there be?
Oh,
I
I
haven't-
like that question.
I haven't written it yet. Which one you prefer more of?
Multiple choice.
Multiple
Short
choice.
answer.
Multiple choice.
Short answer.
Multiple
No,
choice.
sir, multiple choice.
Short answer, you gotta be thinking and you gotta make sure you
Exactly. But if
capture
you see,
everything.
if you see it, it will trigger your memory.
Well, you'll see it in the multiple choice and then you can just apply it to the short
No,
answer.
sir. Mm-mm.
I am being silent. I mean, I've heard this song sung in my last class. Be careful what you ask for, but go ahead.
Let's say percentage.
I
Let's
remember
come
the
to an
warning. I
agreement.
remember the warning Miss Archie gave us in the beginning about a past class who did the same thing and then lived to regret it.
It's
So let's
just
come
so
up with
many.
let's come up with a percentage. So we say either it's 50-50 or 60-40 or 70-30, like what percentage of each we want.
90-10.
Right? What's
And
the next?
multiple choice?
Probably 70-30, which y'all think?
If
Yeah,
it,
like
feel like it's just so
if
much-
it can't be 50-50, then please no more than 60-40.
Because there's so many acts and stuff you have to remember, but if you see them, you would remember.
No.
You really It'll be a question.
Okay.
No. Mm-mm.
Miss Archer, these multiple choice questions that are gonna come in, are they weighted 1 point each?
1 or 2 depends.
Okay.
Miss Archie, you know what I think will help you? When I asked the question as to why there was a challenge with the multiple choice. You said because some of the answers were so close. Why not trick us like that and not make them so close?
That's the thing with multiple choice. You have
Yeah.
to know it.
You have to know it.
You have to know it exactly.
Unless you have scenario, you can explain
Mm-mm.
and explain. You hear that?
Mm-mm.
So although I don't think she'll pose a question like, what year was the Quintel case? Like, but it's,
No.
you either know it's 1979 or you don't know it's 1979. You can't guess that.
And
But
we
you have
won't
to know
know
the
because-
cases in order to know that.
Exactly.
Right. So where are these multiple choices being pulled from?
Chapters 1 through 4.
Okay, so
That
not
was just a
specific
general
details of
question.
the case studies.
No, you'll see that in final exam.
Okay.
We still didn't confirm the percentage, so.
I have something to say. I know majority rules. Majority rules, that's why I stayed quiet. But
Mhm.
if it was up to me, I'd say for the midterm, we could have do the all multiple choice since it's coming out of the book. And then for the final exam, we could have do the structured and the
The
multiple choice.
70-30.
So I don't know.
While I don't disagree, I think maybe having at least some on the midterm will give us kind of a feel for answering them, because that may come as a culture shock if we leave all of them short answer and case studies for the final.
So like 80-20?
Yeah, I gonna have to agree with Krista with that. I
Yeah.
think we should get one or two of those short answers to prepare ourselves for the finals.
That sounds good. The 80-20.
Yeah.
Yeah, that one is
No,
nice.
I,
Open
60,
book?
60, 40. Can we take a vote,
60-40.
please? 60, 40 or 50, 50? Any one of those? Can we get a vote? So that's
Could we put
one.
it in the
Zenobia?
chat? Could everybody put in the chat what they want to do? We could take a count.
Good Lord, say 80.
Okay.
Y'all funny,
Allow me to just submit a little,
Yeah.
I guess, and a recommendation, maybe just 65, 35. That way you get a good blend of both.
Put it right in the chat. Vote in the chat. We can count right quick.
Oh, I just want to confirm, is this open book?
No.
No.
Yeah, that's just it, Marissa. No, it
Thought
wasn't
I
open
heard
book. I asked you, we had the
Yolanda
case
say open
studies.
book.
No, this is not open. Only to be open would be your eyes.
I think we should have at least been able to have the case studies with us because it's a lot. And you still have to have knowledge of what you're looking for if you refer back to a case study.
So will you give us the specific cases to
If
review?
I write any question that refers to a particular case, I will send you an email with that case.
Okay.
Thank you.
Yes, I will tell you. Remember,
I
Else
just
I-
need to pass this class.
you will pass.
I just need to pass.
No, everybody don't want to pass. I like to see people come up to say this is the top student. Come on, let's go.
Oh, Holy Ghost. Mhm.
What's the count?
Voting's
Anyone
about
else
to
voting in the
close,
chat
guys.
so far? We only have
Yeah.
1, 2, 3, 4, 5, 6 people who voted.
That's it?
Seven.
I just voted.
We need everybody to vote quickly, please.
Oh Lord, this going like the
All right, we up to
PLC
9.
70-30.
Oh, I have an answer. Freeport. Miguel said he will send a dress and an email tomorrow.
Okay, because I know the email he sent me said Jeremy's Auto, and I was wondering why.
That don't sound right to me, but anyhow.
Ms. Archer, how many persons are on the call to vote?
Let me see.
12.
2, 4, 6, 8, 10, 12. I have 14 people here.
I see 13 participants.
Oh, no.
8, 9.
No, I have one name twice.
So we only have 9 votes so far.
Well, that sounds like
I can
majority
see.
to me.
That's
What
the
it is?
majority of me.
Yeah,
That's
we go with
majority, so
11.
what?
So we have a tie between 80-20 and 70-30.
A tie.
Yeah.
We need someone to cast.
So
So
You
one
say you have
person.
9. Oh, okay.
That's 75-25 then, meet in the middle.
Okay, I don't think I voted. Would I be the Randall Fox in this class?
Yes.
Yeah.
Come on, Miss Forbes. Do the right thing.
Do this one for the team.
I say 70-30.
Ah,
70-30, got it.
That's
so
it.
70-30 wins.
James, I
Okay.
can give you a cookie tomorrow.
Thank
Oh,
you.
Lord.
I can hold you to that.
820? Oh my gosh.
I think 80-20 win. Check again.
No. See, they came too late. We cut off
1, 2, 3, 4. Yeah, no, that vote came in after we called it.
after we called it. That's why they say you snooze, you lose.
70-30. That's what I wrote. 70-30 it is, right?
Yes, ma'am.
Okay. All right, so I have everything down now, the links for those cases. Cassandra, you didn't do Escobar, but don't worry, you won't escape.
Sorry, Ms. Archer, you said Miguel said he will tell us where if required.
Yeah, he's gonna send you an email.
Okay, good.
Mm-hmm. So if that, yeah, okay. If you do 2 cases, anyhow, further down, I may find some. But I have here.
You breaking up, Miss Archer. Say it again, please.
Now you all are getting a feel for the cases. You can summarize them even shorter. Because remember, everybody is required to read it. At the beginning, I understand. So you could get a feel to see how the judges come to their decision. But now you're getting more familiar. You should be able to summarize it a little bit shorter. Unless there's something in particular you think you need to read out. Sounds good?
Yes.
Okay.
Yes.
So when we do these cases now, the next set coming up, that's going to be a new topic for you because we're talking about the bank exercising its power of sale. I'm also going to give you some cases where persons would have gone to court and they disagree with the figures that the bank is claiming that they owe. So those ones, the first couple that we have here may be a little bit, you may have to go in it a little bit more detail if you have to, and then I have some other ones for us to go through. And then soon cases will be over. Aren't you happy?
Yes, Lord.
Oh, we can get more.
The cases
So-
were interesting, you know. I didn't mind.
Yeah, they were.
Coming up,
Some of them are rather lengthy, but yeah.
some more coming up. So you have 1, 2, 3, 4, 5, 6. And then I'll add to this some more cases that will be done the following week.
Some
So
juicy Bahamian ones, man.
These are Bahamians. All these will be Bahamian cases I'm adding.
Okay, Krista, I send you a message.
Yeah, these will all be Bahamian cases. So I'll add on probably another 5 for the week after that. So these set here will be 27th. And then I'll give you some March. All right.
All right, sorry, Ms. Archer. I just wanted to tell Krista I sent her a message.
Oh, okay. Yeah, that's fine.
Thank you.
Everybody
So,
Ms.
Ms.
Archer,
Archer-
it's 1 through 4, chapter 1 through 4?
1 through 4, yes.
Okay.
And if I write any of the scenario question or any multiple choice question with referring to a particular case, I will send an email and I will say these 2 cases or these 3 cases or whatever cases are cases that you should look at prior to the exam.
Tell me, Gab, please make sure we get those cases.
And then what I will do, I'll say whether it's multiple choice or scenario. So you'll have an idea that if it is scenario, then you have to pay particular attention to what the court ruled.
Okay.
Okay.
Ms. Archer, for future reference, like how we didn't get that email where the cases, to say who the case was assigned to, for future reference, if we don't see it, should we reach out to you and say we
Yeah.
didn't?
Please do,
Okay.
yeah. By which. Okay. So for now, you can start reading your notes. So when I tell you, don't be saying, oh my God, this too. So start studying 1 to 4.
Okay.
Okay.
So I'm looking to see how many 90s I get. So study hard. Fountain, you're the only male.
That's
So
my group, this 100, Miss Archer, what are you doing?
okay.
After that 70, 30, there need to be 100.
Okay, Fountain, the only male. Let's go.
On it.
You on it? Okay, all right. Okay, so look out for the emails tomorrow. I'll start to put these together. All right.
Okay.
Okay.
Sounds good.
All right, thank you.
Yeah.
Welcome. Have a good
All right,
evening.
good
Okay.
night.
You do the same.
Bye.
Good night,
Good
everyone.
Thank you. Good night,
Bye.
everybody.
Good night.
Thank you.
Good night.